Okay, these are the questions you solved last week. So you saw the film Civil Action. In the opening scene where a person was brought into a courtroom on a wheelchair, at what stage of the trial was that scene set? What's the answer? Yes? Anyone? Does anyone remember what the answer was? Well, you got it all right. At the beginning of a trial, right? Okay. Why? That's the question number 2. How did you know the answer to question 1? 여기는 안 되지? Why? 거기 있는 분들은 이걸 보고 저기 있는 분들은 이걸 보세요. 네. 자, what's the answer?
Because the jury and the plaintiffs were present.
Okay. Why? What's the significance of the presence of the jury?
Juries are there when they're doing the voir dire hearings or the trials.
At a trial. Why do we need a jury at a trial? What is a trial that requires a jury? What about a trial that requires a jury? What is trial? Is trial where lawyers argue?
Trial is a fact-finding procedure.
Yes. And who decides facts? Jury. Yes, jury. That's why it is a part of a trial, right? Why is it not after a verdict? Because parties are still bargaining, right? All right. Some of you got it wrong. Third question. In the opening scene, why did defendant's attorney agree to pay money to plaintiffs? The answer is yes, the jury showed sympathy. So, having seen this scene, having seen the opening scene, who do you think decides the amount of damages in a tort case? Jury, right? That's why jury's sympathy is a very important factor when the attorneys were bargaining. Some of you said attorneys decide the amount of damages. Well, it's yes, the attorneys carry out the negotiation on behalf of the parties. In a sense, if there is a better answer than the jury, it will be the parties, right? If there was a choice number 4, parties, that might be a good answer too. But I gave you only 2 options: jury, judge, or attorneys. And their attorneys don't decide. Attorneys carry out the parties' wills, and the parties make a decision on the basis of, most importantly, what the jury might decide, right? That's why the answer is jury. Good. Half of you got this one wrong. All right. Next question. Is the amount of damages question of fact or question of law? Another way of asking the same question is, who decides the amount of damages? It's a question of fact, right? How about number 6? The voice in the opening scene says that a personal injury attorney gets a higher amount of damages award from a jury for a white person's injury than a black person's injury. What does he mean by that? The answer? Yes, it's jury's perception. What's wrong with number 2? Well, even if white people make more money than black people, if the juries don't think that way, they'll not grant greater damages for white people's injury. It's because the jury has that perception that the white victims are compensated better. Okay. Next question. Who are the plaintiffs? Choose the best description. This one was easy, right? Families of the children who died of water pollution caused by nearby tanneries. And who are the defendants? This was easy too. The 2 companies that ran tanneries, Grace and Beatrice. Okay. And 9-1, what are the cause of action stated in the complaint shown on the screen? There are 2 correct answers, and you have to get both of them. They were, if you saw the movie carefully, you actually saw these phrases: negligence and wrongful death. Now, (9-2), how could plaintiffs satisfy the element of the duty, whether defendants have any reason to be evaluated under any standard of care? Okay. What do you think the answer is? What are the four other elements of okay, well, there are three causes of action in torts, right? Intentional tort, negligence, and strict liability. Which one of it was this? Was the lawsuit filed? Negligence, right? Because the tenants didn't mean any harm, didn't mean any harmful action against babies, right? They were just being negligent. And what are the five elements of negligence? Duty, breach of the duty, right, legal causation, and factual causation, and it has to result in damages that you also have to prove. So, the element of duty, how could that be satisfied? What makes it rational that defendant's action is evaluated at all? Right? Yes, I could totally do crazy things right here. And if somebody else get injured outside this room, my action, even if it's a breach of duty, will not be evaluated against the injuries that somebody suffered outside. Okay? Of course, causation will be an important factor, but even before that, if you didn't do anything, right, that's implicated in the causation of the damages, then your conduct should not be evaluated in the first place. Except when there are special relationships. And I talked about those special situations where even if you didn't do anything voluntary, your conduct will still be evaluated. Okay. So here the answer is because defendant engaged in this voluntary act of releasing chemical toxins. Okay. I forgot to bring power cable for my notebook computer, so I'll come back. Okay. So let's take a file. Before I go, let's resolve this. Suyeon,
Yes.
why did you think that there was a special relations between defendant and third parties that caused the harm to the plaintiffs?
Because the companies were hiring those tanners to produce their products.
Companies were,
Contracted, hired.
I see. Yes, but the persons or the companies that were hired, why would their action be relevant? Why does it? Why does those people hired, or those companies hired? Why are the actions of those companies or hired people significant for the purpose of compensating the victims? Because they did some voluntary action that's implicated in the causation, right? So that they hired itself does not create special relationship, and special relationship is recognized only in a situation where the defendant has a very, very dominating, right, and confidential relationship with a third party, like lawyer-client relationship. Pastor, what's the term? Pastor believer. 성도 뭐라고 그래? relationship, okay? Or physician-patient relationship, okay? So these third parties, patients, followers, follower believers, and clients, they depend on the advice of lawyers, doctors, and pastors. Okay? Because of the dependence that the law recognizes, because of the dependence, the law makes special exceptions so that lawyers, doctors, and pastors are held responsible for patients, clients, followers, negligent actions, even if the lawyers, pastors, and doctors didn't do any voluntary act. Okay? So, this company relationship, intercompany relationship, never ever gives rise to a special relationship that will that will replace the requirement for some voluntary action that's needed to satisfy the element of duty. Actually, let's save time. Let's not do that. I'll let you grade yourself. Okay? So pick up your red pen, alright? And promise me that you will not change your original answers. Okay? 9-3. Which of the statements about the element of breach of duty?
So what's the answer for those two?
2? 1. So you got it wrong. So again, the answer for question 7 is families of children, 1. Okay, who are the defendants? Grace and Beatrice. What are the cause of action? Negligence and wrongful death. Okay. All right, 9-3. Which of the two statements about the element of breach of duty are theoretically correct? There are 2 correct answers. Okay. Which of the statements about the element of breach of duty? Okay. 1. As the film shows, at the end, defendants probably violated statutory law in releasing toxic chemicals that caused plaintiffs harm. Number 2, defendants' actions did not breach any duty because it was customary for most companies to release toxic chemicals in the same manner as defendants did. Number 3, defendants' actions probably were too costly in view of the probable cost of avoiding the damages. Right? Defendant's actions should be evaluated at a standard lower than that of a reasonable person. Okay? So there are 4 different ways of showing that somebody's action fell below standard, or substandard, means negligent, right? Now, one is when they violated the statute. So one is correct. Number 2, defendant's action did not breach any duty because it was customary for most companies to release toxic chemicals in the same manner defendants did. This is yet another way of proving breach of duty, the custom, right? But the customary standard applies only to a situation where there is a customary standard to speak of. For instance, among lawyers, among doctors, among companies of certain industry, they form a custom. So, in a situation, so this statement is incorrect because it's assuming that it's not breach of duty if the defendant just follows what others do. Okay? That's not how you form a customary standard. There has to be a strong custom, conscious custom, right? When lawyers and doctors respond to certain cases in a certain manner, they do it consciously, right? They say, given the cost of a response and given the size of the harm that they are trying to prevent, this is the correct way of responding. It is consciously formed. Then we can call it a custom, right? But if some people, by being negligent, just end up causing damages, that do not form a custom because it was not intentionally formed. Number 3, defendant's actions probably were too costly in view of the probable cost of avoiding the damages. That is a typo, avoiding damages, but you could probably guess what's meant by avoiding them. That's yet third way of proving damages. This is in a way kind of economic way of measuring someone's conduct. So, for instance, let's say this is a probability of damage happening, okay? And this is the size of the damage, okay? And then this is the cost of avoiding that damage. Okay, so there is a storm coming. Well, we don't know whether a storm is coming. So here is a boat going out to the sea, and let's say to avoid the storm damage, what's the first thing that a captain or the ship company or ship operator would do to avoid storm? If a storm comes, what should the ship do?
Go to the nearest port.
Yeah. But the storm is fast, right? So you have to know that the storm is coming before the storm comes. And where do you get that information? Radar or, radio, right? So let's say a ship went out without a radio. So it got damaged, right? So the the cargo, okay, the cargo on the ship was damaged because of the storm, right? And the cargo owner sues the shipping company, the ship operator, for damages. When a situation like that, we can measure whether the ship company's action of going out, embarking on the sea without radio, okay, whether if you want to measure whether that action is negligent or not, or whether that action is substandard or not, you look at these factors. What was the probability of the storm coming? Okay, high. What's the probable size of damage when the storm hits the ship? Great. Okay. And you multiply by that. Okay. So you don't actually multiply because they are not really numbers, but you consider both. Okay. And then you consider how cheap it is to avoid this, if you study mathematics, expectation value of the damages. All right? It's the size of damage moderated by the probability, right? If it was very cheap, what's the cost of buying a radio? Very small. So if you consider these three factors, would you say this is negligent or not? Negligent, right? Because it was so cheap to avoid so probable, so great an accident. So not doing it was just completely irrational. Okay. So, one mathematical way of noting that is put multiplication point here and you put something here. Now, let's say P times N is much bigger than B. That's a sign of negligence or no negligence? Negligence, right? What if cost is too great? So it's a very unlikely accident and very small damages, but the cost of preventing it is great. So now in the equation, the right hand side is bigger than the left hand side. Is this a sign of substandard conduct or par standard conduct? Sub or par? Or what I mean is this negligence or not negligence? Not negligence, right? So not taking that precaution, right? Not taking that evasive action was not irrational, was not negligent. Because engaging in that protective action was just too costly compared to the benefit of avoiding the accident. But that does not apply to the case in civil action. Well, yes, that doesn't apply to defendant's actions, because what were the cost of throwing away the toxins? What were the cost?
Lives of children.
Let me see. Actually, all right. I said that it doesn't apply here, but look at number 3 again. Defendant's actions probably were too costly in view of the probable cost of avoiding them. Okay. So defendant's actions caused what? Children's death. So it was costly. And it was very costly in view of the cost of avoiding those damages. What was the cost of avoiding those damages? What should the companies have done to prevent the children's death? Yeah. Right? Not throwing away the toxins, which would have been very easy. Right? So you can say, in this case, I mean, probably the probability of the toxins actually like migrating underground to the water source and people actually drinking the water source, the probability is not that high. But the size of the damage is great, and the cost of avoiding that is very small. So I'll say this is a correct analysis of a breach of duty in this case. Okay. Number 4, defendant's actions should be evaluated at a standard lower than that of a reasonable person. Well, there is no reason to lower the standard for the companies. So that's wrong. So the correct answer is 1 and 3. If you got at least one right, give yourself a triangle. If you got both right, give yourself a big circle. Okay? All right. 9-4. Which statements are correct about causation? Once it is proved that death would not have occurred but for defendant's conduct, causation is fully proved. Okay? Is that true?
No.
No, right? Because?
Both questions
Right.
or partial.
Yep. Yep. There is one more aspect of causation, which is a legal causation, right? Whether the distance, I mean not physical distance, but distance in terms of causation is proximate, right? Close enough between the result and defendant's negligent conduct. Second question. If there was another factory not owned by the defendant that produced more serious pollution near the water source, it will be more difficult to prove proximate causation. Okay. What do you think? Proximate causation. Proximate causation is whether there was a close relationship between what happened and defendant's conduct. And here, if there is another factory producing more serious toxin, that doesn't really affect the relationship between defendant's conduct. Okay, here's defendant's conduct. And here is the damage. The fact that there is a third party causing, that might have caused the damages, doesn't affect the relations between defendant's conduct and damage. So that's also not a correct statement. Third, if defendants caused cancer, but only among children with very serious birth defects, it would be more difficult to prove factual causation. Is this true? Possibly, right? Because but for defendant's actions, the children still would have, or children might have developed cancer, right? So that is correct statement. So 3 is correct statement. If you didn't mark 3, give yourself big X. If you okay. 9-5. Some victims' families testified in the deposition. Which element of evidence does the victim's testimony relate to? Duty, breach of the legal position, factual position, damages. The answer is damages. 10. Was there a trial in this case? How do you know? Anyone? Number 1, the complaint was delivered to Fasher. Number 2, employees of the defendants were questioned by plaintiff's attorneys in the depositions. Number 3, the families of the dying children were questioned by defendants' attorneys before a jury. The witnesses were questioned before a jury. What's the answer? How do you know that there was trial? When there's a trial, who should be there? Jury. Okay. So the answer is either 3 or 4. And what's wrong with the 3? What's wrong with choice 3? Right, they never testified. And that's the central theme of this movie. Why their voices were taken away, why they were unable to testify. And that is why the title of the film is also civil action, because the procedural intricacies of civil action that prevented the victims from testifying. 11. Who are examined in the depositions? Choose 2. Okay. The answer is number 1, the employees of defendant companies, and number 3, the families of the victims of water pollution. Question 12. Choose all the motions made in the case. Who made each motion? What were the rulings on each of the motions? There are more than one correct answers, any one of which you may circle to receive the full credit. Okay. So Plaintiff's motion for Rule 11 sanction. Was this motion made?
It was by the
Yes. It was not made by the plaintiff. It was made by defendant. Okay, defendant's motion to dismiss. Was this made? Yes. Because Rule 11 sanction motion includes motion to dismiss. If you heard the movie carefully. Number 3, plaintiff's motion to divide the trial into 2 phases. Plaintiff did not like dividing up the trial. Plaintiff resisted. Defendant's motion to divide the trial into 2 phases was granted? Yes. Now, that motion was not made with a lot of ceremony. It was casually requested, but it's still a motion. Defendant's motion for, plaintiff's motion for summary judgment. There was no motion for summary judgment. If you watch the movie carefully, at the end of the discovery, the trial just took place. There was no intermediate process of where the evidence was overwhelming enough for either side. So no summary judgment. So the correct answer is 2 and 4. If you got both right, give yourself, well, if you circle any one of it, just give yourself a big circle. Because this was a very difficult question. If you chose either one of 2 or 4 or both, you give yourself full credit. Okay. 13. Choose all the motions made solely orally. It means only without any submission, without any written submission. Okay. Now, Rule 11 sanction, that was made in writing because the judge said, I read all your briefs, that's the scene. So it was not an oral motion. Motion to divide, that was made oral. Okay. And defendant's motion, so number 4, is the right answer. Okay. And only 4. Okay. 14. Why did the families of the victims of water pollution who testified at deposition not testify at the trial? The answer is, of course, number 2. And if you remember, I mean, the fact that victims' families could not testify was a failure to the protagonist, the attorney, Strickland. Right? Remember the opening scene. How did he win the case? By bringing a guy on a wheelchair and making the jurors cry. By showing the victims silent testimony, and by presenting him and his injury, he stole the juror's heart. And Strickland could not pull that trick in this case because the victims were never brought before the jury. And it's terrible because why were the victims not there? Because they died. Right? If the children survived in one form or another, just having the children on a wheelchair in the courtroom might have affected the jury. Right? But the jurors never got a chance to see how grave a situation that they are handing out justice on. That's the main kind of suspense. And I mean, most suspenses in legal drama are not really legal, but here it was really legal. Right, question 15. Defendant's attorney Fasher says, after one deposition, I will not let them testify. Ordinarily, what procedure does he have to follow in order to accomplish his intent? His intent to, his intent to prohibit victims' families from testifying. What is usually the standard procedure? Okay. The answer is motion to exclude evidence. And did he use that? No, he didn't have to. Because he divided up the trial. Right. Question 16. Right before the trial began and after all the depositions were done, do you think that the case could have been resolved on summary judgment? What do you think? What is a summary? Question 15. Yes. Yes. Yes, you are right. Okay, since you raised your hand, what do you think the other answer is? Yes. Right. Because if a case is disposed of through summary judgment, trial never takes place. But that's not entirely correct answer, because if the trial doesn't take place, nobody can testify. There is no testimony at all. But since I said there are two correct answers, yes. If you chose to, give yourself full credit. But remember that I had this, okay? I was very reluctant, right? Because not having a trial prohibits everybody from testifying. But motion to exclude evidence, it can pinpoint to certain testimony and exclude just that testimony without hurting the entire trial. Okay? 17. Please choose at least one question of fact given to the jury in the form of jury instruction. 16. Right before the trial began, after all depositions were done, do you think that the case could have been resolved on summary? What is summary judgment given? Why is there such thing as a summary judgment? Summary judgment, what is summary about it that it's called summary judgment? Evidence. Or more like testimony. Because evidence is already there before the trial, because that's what you prepare to the discovery. To the discovery, you get information from the other side, you get evidence from the other side, and you accumulate it and you prepare it for the trial. So, summary judgment is summary judgment. If there is a summary judgment, then there are no testimonies. And why do you have testimonies? To resolve a question of law or question of fact? Question of, okay, question of fact or law? Fact or law? Fact. Testimonies are given to resolve question of fact. Because testimonies are all factual assertions. I saw a car pass a red light. I saw that man's face. Right? I saw that woman's dress. These are all factual assertions. And look at the content. There is no legal argument. These testimonies cannot resolve a question of law. It is a question of fact that they are designed to resolve. So, for summary judgment to be granted, there should be no question of fact. Okay? The reasoning goes like this. There is no question of fact, so there is no need for testimonies. That's why you have no trial. Since you have no trial, you have summary judgment. Or more like that you don't have testimonies means it is a summary judgment. That's the definition of a summary judgment. That you decide without listening to testimonies. Okay. So, having said that, what's the answer? 2, right? And it was obvious, right? Because at the beginning of a trial, the judge gave a set of questions to the jury. What do you think those questions were? Do you think those were legal questions or factual questions? Factual questions, right? That means that summary judgment was impossible because factual questions were not resolved through the discovery process. Okay? A mountain of evidence on both sides did not converge on a singular set of facts about this case. Rather, mountain of evidence on both sides were pointing to conflicting facts, which means there were questions of fact. That's why the jury were pulled in to decide on those questions. So the correct answer is number 2. Any other answer? Wrong. Okay. 17. Please choose at least one question of fact given to the jury in the form of a jury instruction. Okay, which one?
Number 2.
Did the defendants pollute water? Okay. And what are the wrong answers? Number 1. Because there was no factual question that plaintiffs died of leukemia. Okay. That question of fact was not given to the jury. And what other correct answer is there? Number 3, did the defendants negligently harm the plaintiffs? How about number 4? That question was not given to the jury either. Okay? It was established that the children drank the water. Okay? So correct answer is number 2. Number 2 and 3. 2 and 3.
So we get marked when we get either 2 or 3.
Yes, you get full mark if you got either 2 or 3. Okay, you get full credit if you got either 2 or 3. If you got both 2 and 3, then draw a bigger circle. 18. Was there a verdict? If so, what was the nature of the verdict? Now, general verdict, special verdict, I didn't talk about this in class, but it was in your manuscript. It was in your lecture note. Did you read it? If you didn't read it, you could not have gotten this right. Somehow you got it right. Okay. Now, general verdict calls for the jury's decision on who won by how much. That's the general verdict. Special verdict asks for a special question to be answered by the jury. Okay. Here, did it ask for special verdict or general verdict? The jury, the judge, special verdict. So that's why the judge, that's why the jury found in favor of one defendant and not in favor of the other. Okay, so the answer is number 5. Any other answer? Wrong. 19. Was there a judgment in this case? If so, what was the nature of the judgment? Was there a judgment? The correct answer is number 3. The judge ordered the trial to continue for one defendant and dismiss the case for another defendant. Any other answer? Wrong. If you are a plaintiff's attorney, would you appeal the judgment right after the judgment was announced? What will be the basis for your decision not to appeal on or the basis for your appeal if filed? Would you appeal or not? You will not appeal. Because?
It's difficult to challenge.
Right, this was a factual, why did plaintiff's attorney lose against the batteries? Right, the bigger company, right? Because the jury decided on a question of fact against plaintiff, right? So I told you that the facts are decided only at the lowest level, and they are not disturbed through appeal. Okay? So number 2 will be a correct answer. Yes, so that's the correct answer. 21. Please explain why one defendant agreed to settle and the other defendant did not. What's the answer? This one you can get it right. You can get right even if you didn't study American law at all. If you just watch the movie carefully, you can answer this. What's the answer? Number 4, right? That defendant lost in the first phase of trial while the other defendant won. Assuming that the defendant did not settle with the remaining defendant, what would have happened afterwards between the particular defendant and the plaintiffs? So Beatrice the case against Beatrice was dismissed, right? Because the jury found a special fact against the plaintiff on Beatrice. But on Grace, because the trial continued, because the jury found in favor of plaintiff on Grace, Grace settled with what, 8 million, 6 million, right? What would have happened afterwards between that particular defendant? So Grace and plaintiffs. The answer is, what would have happened if Grace didn't settle? Say it louder.
The finished phase of the trial.
Would have continued. Yeah. 23. Plaintiff's attorney, after settling the Ubon case. Ubon case is the case that you saw the movie of. Went to get food at a restaurant and saw children spill water on the table, which a waitress cleans up. How did that inspire his subsequent conduct? What's the answer?
3.
That was confident. Yes, 3. Okay. You are silent in all the other questions. This one. Okay. You're a movie buff? I mean, number 23, you could, you know, you can get that without really studying law. Just watch the movie very carefully. 24, after the conclusion of the film, which of the two defendants could plaintiff sue again? Okay. After the conclusion of the film, which one of the defendants could plaintiff sue again? Beatrice or Grace? What do you think? You're a smart one, so you know something. Beatrice, yes. Grace, you can never sue because you said it. But with Beatrice, yes, I mean, generally it's impossible to sue Beatrice again because Beatrice already won on a special verdict. Okay? On a special verdict that their toxins never affected the children. Okay? But there is always, I mean, in any civil procedure, 한국에도 재심 절차 하는 거 있죠. 그래서 전 재판에서 얻을 수 없었던 증거가 새롭게 발견돼요. 그건 어느 나라나 그런 제도가 있겠죠. 그래서 so for Beatrice, plaintiff could find new evidence not discovered at the trial court. And what was the new evidence? Okay.
I'm
No.
the guy who don't.
Oh, you have to answer this in relation to question number 23.
There were 2 dump trucks.
Dump trucks were used to what?
Clean up the toxins.
To clean up, not to dump. To clean up. See? That's the inspiration that he got from the waitress cleaning up after the children who spilled water on the table at a restaurant. Right? So he thought that, oh, I was looking at the wrong place. Because when the lawsuit began, you know, they looked for area where the toxins were dumped, but there were no toxins. Okay, so he realized that there must have been people who cleaned up. Of course. So for Grace, remember the bald guy is like he's Italian. He comes up in that actor comes out on in Sopranos, right? And I think he's Italian. He comes out as a mafia a lot, and he played a employee of Grace or Beatrice. Didn't follow the movie closely enough. he was the employee of Grace. Right? That's why the jury found against Grace on that special question. But there was no such employee, there was no whistleblower like him for Beatrice. Right? But what did he testify? He testified about dumping the chemicals. Right? So all throughout the case, the lawyers were looking for people who dumped the chemicals, but never looked for people who cleaned up the chemicals. Right? So after the lawsuit ended, he finally thought of that, and he found one employee of Beatrice who cleaned up the toxins. So for Grace, they had whistleblower on dumping. For Beatrice, he found whistleblower on cleaning up, but only too late. Right? Was there an appeal filed? Yes, new evidence against Grace. Yeah, that's not how it went, right? So what happened? I mean, he could have appealed, because now he has new evidence. But in the movie, he didn't do that. What did he do? He sent the documents to the government. Right? EPA, Environmental Protection Agency. And they make Beatrice clean up the area, detoxify the area. But I don't think the EPA ordered the company to pay compensation to the victims, because that's not the role of the EPA. Now, in the real case, of course, they filed an appeal. But in the movie, I hope you only answer the question based on the movie. In the movie, the appeal was not filed. And one reason that, it might have been good, at least within the movie, one reason that the appeal was not filed was because this evidence of cleaning up, was this really new evidence? Or was this pre-existing evidence that plaintiffs never got to? Right? 재심은 아무 때나 받아주는 게 아니죠. 네, 그래서 재심 재판이 열리는 경우는 거의 없어요. 한국도 마찬가지고 미국도 마찬가지고. 그래서 원고가 첫 재판 때 확보할 수 있는 거였으면, 가능성이 조금이라도 있는 거였으면은 그걸 나중에 찾았다고 해서 재심을 할 수는 없어요. 그래서 이것도 보면은, it was just a matter of inspiration that the plaintiff's attorneys never looked into the cleanup evidence as opposed to dumping evidence, right? So you cannot seriously call this new evidence. This was pre-existing evidence that they never, got around to access. They never got around to present. Okay, all right. If you scored yourselves, please give me back your test.
Can I ask something?
Sure.
So question number 20,
Uh-huh.
for the appellate court, I thought it was only about the judicial decisions. For number 20,
For number 20,
isn't the appeal based on the questions about the law?
Right. Appeal can be filed only on questions of law. You are right.
But
That's why number 2 is correct answer, because because questions of fact cannot be appealed. Right? The baby dying on the way to the hospital was just so strong in my memory that I never really thought of that part of the testimony.
Which question?
9-5. 9-5, if you chose factual causation, that can also be a correct answer, because in the deposition there were testimonies about plaintiff's other behavior of eating carcinogen or living around carcinogens. Okay, any other question?
So when they say causation in this kind of question, it means factual plus legal causation?
Well, that testimony was
No, I mean 9/4.
9-4? I was talking about 9-5.
Yeah, okay.
Yeah, not 9-4. Okay, all right, let's get okay.
The question 9-4, and you said the answer was 3.
Okay.
And what exact? I didn't get your
Explanation.
explanation.
Which statements are correct about causation? Well, number 1 is wrong because causation,
Yeah.
right? Okay, number 2 is wrong because someone else doing whatever else does not really affect your proximity or defendant's proximity to the result. Number 3, is correct, right? Because the children might have developed cancer but for defendant's action, right?
What does the proximity, what do you mean by proximity is not affected?
Okay, I mean, if you're not going into detail, it works like this. So proximate causation is like now I talked about this example, right? I give you wrong class time to meet like next week, and because I gave you wrong class time, well, my giving you wrong class time is breach of duty, right? Because probably somewhere in the rule book, it says the teacher should give correct class time if teacher wants to change, right? So probably I violated the rule when I gave you wrong class time, right? So there is a breach of duty already. Now, because I gave you a wrong class time, you got on a bus that will get you to school for that class time, but the bus goes into an accident and you get injured. And should I be responsible for your injury, right? And that, in that case, there's a factual causation, full factual causation, right? Because but for my mistake, you would not have been injured. You would not have been injured, right? But is the causation proximate enough between my mistake and your injury? Or could it, is it something so remote? Is it something so remote from my perspective that I should not be held responsible? Okay. How could I have known that you will get on bus instead of taxi or subway? How could I have known that the bus that you get on will have a negligent driver? There's so many uncertainties that I cannot be prepared for or I cannot be responsible for just on account of my mistake about class time. Okay? So that is not really affected by, for instance, like, other bigger accident that happened on that day, right? Of course, if I knew that there was a very dangerous driver that will, ram into buses and taxis, then yes, you can say that there is more proximity between my action, my mistake, and the accident. But barring that, the presence of a dangerous driver on the street will not affect my relationship with damage. So, do you see the analogy between that case and number 2?
But like in this case, this is the water pollution, so these companies may not be responsible for the children's death when there is a more serious pollution made by the other factories. So
Yeah, but does it affect proximate causation or factual causation?
like you said, proximate causation is about responsibility.
Yes. Sense of responsibility, yes.
So maybe that the pollute made by other factory may be responsible for the children's death, then it can affect the proximate causation.
Yeah, but when I say sense of responsibility, I'm not really talking about who should be responsible in the end. I mean, you shouldn't replace the responsibility talk with the proximate causation, because responsibility is a bigger concept, and we broke it down to 5 different elements, right? But duty and proximate causation are more about like sense of responsibility, right? To whom am I accountable, right? To whom should I feel a sense of responsibility? Duty and proximate causation appeal to those senses, but still proximate causation is about causation, and the statement is, you can make an argument, but it's more about factual causation. The fact that there is another polluter.
I'm curious because this phrase is saying that more difficult to prove.
Mm-hmm.
So I think it can make sense because if the sentence does not say there is no proximate causation, it is saying that more difficult to prove proximate causation.
So what would proximate causation be in Korean?
없죠. 상당한 인과관계.
I actually do agree with what they're saying. Actually, I kind of have the same question. Maybe I'm just talking semantics, but if the statement just said there's change or no change, it has effect on the actual proximate causation or not, then I would agree with the explanation that the professor provided. But since the statement itself is just saying it's more difficult to prove, I was curious, like, how do we actually prove the proximate causation? And if we're proving by how the water flows or the statistics, how much of a concentration of toxic materials are there, there's other factories. Because we can't actually trace the toxic, where it's coming from, so it'd be harder.
Yeah. Well, you may be right, but in my class, it was supposed to be a trick choice, because there the sentence makes much more sense if it says factual causation, right? So just for the educational value of it, just forgive me. I will not recognize.
Oh, and
Yeah.
I was confused because you said which statements are correct. So it was 17. I got the wrong answer.
Okay, I'm not that nitpicky with the grammar. Okay, this is just only one of the tests, so we're doing on this. Okay, all right. Give me back the test.